In a step that shows how fake news or fake information being passed through social media or digital platforms affects individuals and families, superstar Amitabh Bachchan's granddaughter, Aradhya, had to move the Delhi High Court seeking pulling down of fake and insensitive news about her health. Acting on the plea, the High Court restrained YouTube channels from spreading false reports on Aradhya Bachchan's health and directed Google to take down videos about the fake news from its platform. This incident only goes on to show how difficult it is for individuals who are at the receiving end of fake news to get the platform or the channels to take down false information. Not just India, countries across the world are grappling with the problem of effectively regulating social media and online tech platforms. The European Union seems to have made a good beginning with its Digital Services Act, and now the EU has notified 19 media firms as very large platforms under the DSA, making it obligatory for them to provide greater degree of accountability. The rules require these companies to do risk management, conduct external and independent auditing, share data with authorities and researchers, and adopt a code of conduct latest by August this year. The EU says that some other companies too could be added to the list in the coming days. Among the companies and apps that are included in the list are Google Maps, Google Play, Google Search, YouTube, Google Shopping, Meta's Facebook and Instagram, Amazon's Marketplace, Apple's App Store, LinkedIn, Bing, Booking.com, Pinterest, Snapchat, TikTok, Twitter, Wikipedia, Zalando, and Alibaba's AliExpress. These companies can be fined up to 6% of their global turnover in the case of non-compliance. In extreme cases, their access could also be temporarily blocked. The Digital Services Act is aimed at improving content moderation on social media sites and addressing concerns about fake news, disinformation, crimes like child pornography, etc. The Act has 5 chapters, but Chapter 2, Chapter 3, and Chapter 4 are considered to be most important. Chapter 2 is related to liability exemption of intermediaries. It says that independent platforms that host content shared by others are not liable for wrong content unless they know that it is a lie and then don't act to remove such information once they know that it is false. Chapter 3 of the DSA is about obligations of such platforms. This imposes certain amount of transparency by making it mandatory for some firms to disclose how their algorithms work and how decisions are taken about removal of such content. This has been a contentious issue because often it has been alleged that those at the helm in organizations like Twitter and Facebook have not taken an unbiased stand while regulating content. The Twitter files, released after the takeover of the social media giant by Elon Musk, showed how skewed the content moderation practices were at the organization. Platforms would also have to maintain a certain degree of openness about how advertisers on their site target users. Chapter 4 of the Act is about how platforms will work with the national law enforcement agencies. Before this, there has been a view that social media firms, or in fact any tech service provider, is a private firm and government can't intervene unless there is direct suspicion that some illegality is involved. That is how most social media giants have stayed away from public scrutiny till now. But Chapter 4 of the DSA requires such platforms to redress concerns over content removal and moderation, take actions like comprehensive risk management, and conduct external and independent auditing. Now, the strictest rules of the DSA apply only to very large platforms that have a monthly user base of 45 million and above. And this is why the decision by the European Commission to name the 19 companies is important. So, all the companies that are in the list are perhaps the most popular social media sites or shopping sites, and now they will have to take steps to increase transparency and be more accountable. Now, as far as India is concerned, it has its own Information Technology Act, which has been amended from time to time. This law regulates the functioning of tech platforms. However, there is much room for improvement.
India also has certain rules and regulations for companies like Meta, Twitter, Amazon, Google and Apple. For example, in 2021, the Indian IT rules, which were amended, were targeted at Meta and Twitter, with the government wanting more regulation on what kind of content actually goes there. Even WhatsApp was told that WhatsApp or other companies were told that they need to have, say, a grievance officer or certain other rules which have to be followed by social media companies. WhatsApp and other companies had objected to certain rules which the government wanted to introduce. Similarly, there is the ONDC, the Open Network for Digital Commerce, which is targeted at bringing e-commerce sellers, big or small, including the likes of Amazon, Flipkart, Walmart, under the rules, which does create healthy competition and does not stifle growth for smaller retailers.
However, the government is planning an overhaul of the current laws and bring a new Digital India Act by the end of the year to regulate such companies. The government says that the new act will prevent concentration of market and gatekeeping by big tech firms. It is also aimed at ensuring more freedom to choose for the consumers, along with competition, fair market access, and ease of doing business for the digital companies. As consultations are underway for a new act, the DSA might provide a guiding light on ways and means to regulating digital tech platforms. Hopefully, the new act will be more effective in countering fake news and disinformation, and at the same time will provide ways by which anyone who is the target of fake news, like Aradhya Bachchan was, to obtain resolution from the social media platform itself, rather than having to move courts each time. That's all for now. Keep watching Times of India.